one. Welcome to Actionable Intelligence. I'm Eric Greitens. As always, I'm honored to be with you tonight. This is the show that respects your intelligence. We honor you as a citizen, and we work every day to bring you the facts. We've got the courage to bring you the truth, the insights, and the points of view that are so often ignored or censored by the mainstream media. Now, today we learned that a lawsuit submitted by President Trump's allies concerning the vote in Pennsylvania is expected to make its way to the Supreme Court. Pennsylvania State Representative Mike Kelly and others contend that the vote in Pennsylvania was conducted with what they called an unconstitutional, no-excuse absentee voting scheme. Now, as these cases make their way to the Supreme Court, many of you have asked us, how successful are these petitions likely to be? When speaking with John Solomon during an earlier election special on this channel, renowned legal scholar Alan Dershowitz had this to say.
Are you convinced that this is going to end up at the Supreme Court, that these 3 or 4 states are going to all end up before the Supreme Court? Is that where this legal trail ends?
If the numbers are there, not if
Right.
the numbers aren't. The Supreme Court's not going to issue an advisory opinion. They're not going to issue a moot opinion. They're not going to give Trump a Pyrrhic victory. The plaintiffs are going to have to show that there are enough votes to impact the outcome of the election in a given state. If that happens, yes, it will go to the Supreme Court. And yes, I think at least under the constitutional challenge, the Article 2 challenge in Pennsylvania, they have a pretty good chance of winning.
Now, Professor Dershowitz, host of the podcast The Dersh Show, joins us now. Professor, thank you so much for joining us.
Well, thank you for having me.
Absolutely. No, sir, one of the big things that our audience loves is the fact that, we're willing to bring them facts, perspectives that they often don't get in other places. And before we actually get into the specifics of any particular case, I'd love it if you could break down for our audience the 2 big issues, namely equal protection, and then also the constitutional challenge, where the Constitution says specifically that state legislatures shall set the time, place, and manner of elections. If you could break those 2 big challenges down for our audience, we'd appreciate that.
Well, I appreciate that. I pride myself on always giving a straight legal analysis. I don't give wishful thinking like some of my colleagues do. The law doesn't always correspond with my particular politics, but I'll tell you what the law is.
Right.
So there are 2 basic challenges. One, Article 2 of the Constitution says the legislature will determine the manner of electing electors, and not the courts, but the legislature. And in Pennsylvania, what happened is the courts expanded by 3 days the amount of time which ballots could be received. I suspect this Supreme Court will strike that down. We already know that Justice Alito has segregated out, ordered the segregation of those ballots. So we'll know how many ballots there are. Whether there'll be enough to change the outcome of the election is questionable. The other issue is equal protection, and that is, in some counties in Pennsylvania, apparently, they allowed voters to come in and correct flawed ballots. And in other counties, they didn't. Under Bush versus Gore 20 years ago, that may well constitute a violation of equal protection. Voters in different counties shouldn't have their vote determined by different mechanisms or methodologies. That's what the Supreme Court decided back in 2000. So those are the 2 core issues. But in both cases, the numbers have to be there because the courts are not in the business of giving advisory opinions. So the first question that will be asked the plaintiffs is the margin of victory that now Biden has over Trump greater or less than the number of challenge ballots that you would like to ask us to discount or count for your candidate? And they have to answer that question.
Right. And then, one other thing I'd love your perspective on, Professor, is this idea of evidence. One of the things that we keep hearing repeated again and again is that people have said there isn't any evidence of fraud. We know, we've covered on this program, there have actually been hundreds of people who've come forward who've signed sworn affidavits, some of them saying that they were actually ordered to participate in backdating of ballots, for example. Just break down for us from a legal perspective what constitutes evidence, and is there evidence of fraud that you've seen in this election?
Well, there are 2 kinds of legal challenges. One is wholesale, the other is retail. The 2 I just mentioned, equal protection, Article 2, they're wholesale challenges. They don't require you to look at every ballot. They require you to look at categories of ballots. once you get into the issue of was this vote proper, was this vote not proper, was this vote filed by a dead person, you're getting into retail. At that point, you need evidence, and evidence is subject to cross-examination. You need a trial. The clock is running out. We're down to the 2-minute warning, and there are no timeouts left for the Trump team. So they have to be pulling, rabbits out of the hat at this point, and they have to do it very, very quickly. And they have to show, again, enough numbers that would make a difference in the outcome. I think it's very, very difficult for them at this point to reverse the presumed result of the election. But I don't blame them for trying. That's what lawyers are supposed to do.
And walk us through and walk our viewers through specifically the timing issues that are involved here so that people get a sense for the calendar and what needs to happen, please.
We have some soft deadlines and some hard deadlines. Soft deadlines, though, what's called the safe harbor provisions. That's not really important. The important date is the 14th of December, when the electors are supposed to cast their votes. Then there's a date a little later on when Congress certifies those votes. And then, of course, the big day is January 20th, when the president raises his hand and is sworn in. But everything really has to happen before the 14th of December. But I'll give you a crazy hypothetical. Let's assume that by the 14th, it's clear that one candidate or the other wins. And then they discover afterward a major computer glitch that shows that tens of millions of votes, which really would have changed the outcome of the election, were improperly cast or were fraudulently cast. Nobody knows what would happen. We've never had that before. So one can't be absolutely confident, even that December 14th is the absolute deadline. If you had a catastrophic event post the 14th and before January 20th, nobody knows how that would be handled by the Supreme Court.
Excellent. And Professor, I want to switch gears here a little bit, actually away from the specific cases to kind of the culture that we're seeing in the United States. One of the things that you've talked about on your podcast is this kind of creeping culture of McCarthyism, specifically with not creeping, but this galloping culture of McCarthyism, where you've actually had people come out suggesting that you should disbar President Trump's attorneys just because they're representing a client that they disagree with. Talk, if you would, please, about how dangerous this is culturally right now.
Well, this really started with me when I defended President Trump on the floor of the Senate. A group of bullying students at Harvard College circulated a petition trying to take away my emeritus professorship, which I had earned for 50 years of teaching and 10,000 students. But because I had the nerve to represent the President of the United States on a major constitutional issue, I would normally laugh at that. But at Harvard, the university fired the dean of one of the colleges for representing Harvey Weinstein. And if the university could do that, surely they could try. Believe me, they wouldn't succeed. I'd be in court in 2 minutes, but they could try to take away my emeritus professorship. And trying to disbar Rudy Giuliani, you could agree or disagree with his tactics, but he hasn't done anything warranting disbarment. I'm not worried about Rudy. He can do fine. What I'm worried about is young lawyers who read about this. Oh my God, I don't want to be disbarred. I don't want to have my assistant professorship without tenure taken away from me. So I'm going to become a coward. And America is going to become a nation of cowards, unwilling to express principles, to support unpopular causes, defend unpopular people charged with crime. That's not the kind of country I want to live in. And at 82 years old, I'm going to continue to fight as vigorously against it as I did against the real McCarthyism when I was 18 years old.
Well, look, and it's a very basic principle of the founding, was that you should be able to have unpopular opinions. The entire idea of a republic where you have citizens who have constitutional rights is that you are able to actually exercise those rights without majority, a tyrannical majority.
John Adams, who helped draft the Declaration of Independence and the Constitution, our second president, incurred enormous criticism for representing the British soldiers who engaged in the Boston Massacre. That wasn't designed to win him any popularity contests. And we saw that with many American heroes up through the years. So, of course, our First Amendment was designed not to protect popular speech, but unpopular speech. But these students at Harvard have no idea of their history. They're a bunch of spoiled brats. They're a bunch of snowflakes, and they ought to be answered. They shouldn't be just accept, oh, you're young, you're young. No, no, no. You're the future leaders, and we're going to fight back against you.
Absolutely.
And we're going to prove that you're wrong in the marketplace of ideas.
Absolutely. In the 30 to 40 seconds that we have left, Professor, if you could talk a little bit about the pardon of Michael Flynn and what you think that means, not just in this specific case, but for future pardons.
It was exactly the right thing to do. The pardon power is not only compassionate, it's a check and balance on excesses of the judiciary. What happened is Judge Sullivan exceeded his authority in the case, and he was smacked down by President Trump, as he should have been. It was exactly the right kind of pardon to issue. But you wouldn't believe that if you heard some of my Harvard colleagues talk about it, because they always take only partisan positions on these things. So it was exactly the right thing. The president ought to pardon widely, both for compassionate reasons and for checks and balances reasons. I hope he will do so. I have some cases in front of him seeking pardons. Other people do. There are death penalty cases. There are pro bono cases. There are poor people in prison. You ought to look broadly at these issues of pardon and commutation.
Awesome. Well, Professor Dershowitz, we very much appreciate you coming on. I know that our viewers do. I personally do. Thank you, sir. Very much appreciate your insights and perspectives. And folks, we'll be right back with more on Actionable Intelligence. Stay right here.